Hello, all. Welcome to this new session of the course Legal Essentials for Human Resource Management. This is week 2 and session 7. If you remember, we were discussing in the previous class about certain definitions of very key terms such as work, employment, and wages. In this today's session, we will look into the basic ideas behind drafting employment contracts. My name is Dr. Amish Samalopanan and I am an assistant professor at Nalsa University of Law. Now, what is a contract? Before getting into the details of definitions of employment contract, let's see what is a contract to begin with. Now, according to Indian Contract Act of 1872, and all our discussions are going to be primarily based on the Indian Contract Act, an agreement is, or a contract is, an agreement between two or more parties who make promises to one another. It's essentially promises that two or more parties have made to one another. Now, given that it has a statutory backing, the court can enforce the rights and duties arising from it, and that's what it makes this agreement very important. Now, I have said that these contracts are legally enforceable. The rights and duties that emerge out of these contracts, rather employment contracts, are enforceable, but there are certain conditions. For contracts to be legally enforceable, it must satisfy all these essential elements that I'm going to list out. First, the concept of offer and acceptance. So how does an employment contract work? First, there should be an offer that has been made by the employer. So always an employment contract should work in this fashion, that the employer will make a offer letter where all the clauses regarding employment is mentioned. Now the employee, who is the other party, will accept it without modification. So employer will make an offer and the employee will accept it without modification. Now, only if this process have done, that employment contract is valid. The whole idea is that there should be a mutual consent. If the employee does not accept to some of the clauses, if his sign is not there, he is not consented to the contract to begin with, it is not a valid contract, or it's not a legally enforceable contract. So ensure that whenever you're drafting employment contract, you go through this process of offer and acceptance. Second concept that you should keep in your mind is the concept of lawful consideration. All these concepts are mentioned in the section 2 of Indian Contract Act. What is lawful consideration? For a contract, I told you, the definition of the contract is that it's certain promises two or more parties give to each other. So it cannot be a one-way communication or a one-way take that happens. It should be give and take. That's the concept of lawful consideration. There must be something in return. So if the contract speaks that the employee should be coming at 8 o'clock in the morning and leaves at 6 p.m. 6 days a week, fine. And he does these kind of jobs, fine. But something has to be given back to him in return of his promises. That's the concept of lawful consideration. Essentially, it's the salary or any other benefit that you promise to give. If you see in a contract there is no consideration, if there is no exchange happening, there is nothing given in return, it is not legally enforceable. There are few exceptions to this, but over and more, that's the concept. So, for example, some of the contracts where out of love of affection, but it's very dicey, it's very difficult to prove it that way. Just to understand that something in return, consideration, lawful consideration should be there. Another is competency of party, section 11. So both the parties must be legally competent, must be 18 years or older. This is one criteria. You have to be 18 years or older. There was this scenario where Vaibhav Suryavamshi, who is a player for Rajasthan Royals, he's apparently only 14 years old. How did he sign the employment contract with Rajasthan Royals? He's a minor. So probably his parents would have done it in his behalf. So both the parties must be legally competent, must be 18 years or older and of sound mind. If somebody proves that one of the party is of not sound mind, then the competency of the party is questioned. Another consideration is what we call as free consent, section 14. The consent is that there should be a mutual agreement, mutual acceptance. So the consent that comes from the party, any party, should be free from coercion. He should not be forced to sign the agreement. If somewhere you can prove that he was forced to do it physically, it is null and void. There was an undue influence. He was not physically forced to do it, but some other way he was forced to do it through some influence. Then also this contract is not valid. It is a fraud. He was being cheated. He was being promised something and then made him to sign this agreement, sign this contract. Then also it is not legally enforceable. And finally, if there is some misrepresentation, any sort of misrepresentation has been made, then also this contract will not be legally enforceable. So you as business owners, HR managers, or even law students, the fine reading of a contract is reading through all these concepts. Ensure there is no scope to raise any such objections later. Another concept is what we call as lawful object, which means that the purpose of a contract must be lawful. Everything regarding the contract is perfect. There is give and take. Everybody is of 18 years plus of sound mind. But this is regarding selling of an illegal stuff. It will not stand enforceable in front of the court. So the purpose of the contract should be lawful. An employment contract to do illegal work will automatically be void. Now another concept is concept of not declared void. The contract must not fall into any of the categories declared void by this act. Those categories are of course agreement without consideration that we had discussed a moment before, which means that it has to be a give and take. If there is no give and take established in the contract is not valid. Agreement should not lead to restraint of trade. Agreement must not say that, because as an Indian citizen, every employee has the right to profess his work. The right to profession is guaranteed by the contract. By the constitution. So if the contract restricts him from indulging in any sort of job, because if you discuss all the basic judicial interpretations, you will know that right to work is essentially right to life. So nobody can be stopped from working. So if there are any agreements that leads to restraint of trade, restraining from working somewhere else, it's declared void. But of course, there are some subsections you should know. There are some restrictions which are allowed, which we will be discussing in the next session. To keep it lightly, if a monetary compensation is given for it, or whether the employer can prove that there is a particular trade secret which will go out if the person indulge in another activity right after leaving our job. Such scenarios are there. We'll discuss that in the next class. And any agreements opposed to the public policy, which means that anything that is against the law of the country, against let's say it's a contract written to curtail peace of a particular place or something, so they are also not considered legal, and they are not legally enforceable. Now what are the various things that we should include in an employment contract? Now this is a question that I've been asked very often. Like, in an employment contract, what are the basic things that we should include? See, as I told you, it's a mutual agreement of promises between an employer and employee, and there is no exact answer to the question, give what all must be there, should be there, and all. But I can just discuss a general nature of an employment contract and what are the essential features that should be included in the employment contract, because that will ensure that you have covered all the bases. The first thing is the details of the party, very important. Full name, address, and designation of both the employer and employee has to be clearly mentioned in the employment contract. Otherwise, later it's gonna be this is very basic. Any contract ensure full name, address, and designation of both the parties, or more than two parties are there, all of them. In the employment contract, it's an agreement between employer and employee, so ensure all the designations are clearly mentioned. And proof of identity and registration of the employer has to be mentioned for sure. This is a basic. Now, when it comes to employee, the job title and the description has to be clearly mentioned, because it all starts from what is his job title. Then you kind of explain what job he will be doing. So the designation, which department he will be working, duties expected, and whom he will report to. It doesn't have to be a name, it can be general, but basic reporting structure has to be explained in the employment contract. The term of the employment also has to be mentioned. We discussed there are two types of employment, fixed term and permanent. So depending upon which sort of employment it is, permanent, fixed term, probationary, please mention the terms of employment. So if it is probationary, now that's a scenario where the employer doesn't want to extend the permanent employment right away, and he will mention a condition that you have to work for 1 year, 6 months, and we'll see if the performance is satisfactory. And only if the performance is satisfactory, we will proceed with the full-term employment. So such details, if you want to have a probational part, you can include all those. Clearly mention the start date, and if it is a fixed term, end date. Another thing that should be included without fail is the details regarding working hours and location. So in a week, how many hours he is supposed to work, what are his break times, weekly off, when is it? Is it on a Sunday or on a Wednesday? When is the weekly offs? Where is a place of employment? Where will he be going to work? Now this becomes important because most of these MNCs or any of these places might have multiple branches. So if you wanted this person to join at a particular office, you have to clearly mention, okay, this is the place of employment, and later as the need be, you might be transferred. So it's very important that you include potential transfer clauses also. Consideration has to be mentioned in the employment contract to make it legal. The considerations include salary details, wage structure. So, what is the basic? What are the allowances? Any bonuses obviously does not get mentioned in detail. But if it is a performance linked bonus system is in practice, you can include that. Like we generally provide this many percentage, वगैरह, but it's better depending upon the profession he is, so that once it is in the contract, it becomes an obligation to provide bonus. Now there is also a bonus act which promises a minimum percentage of this much amount if the company is running in profit. It's another thing. We will get into that also. So you mention all the salary based structure, payment schedule and mode. What is the mode of payment as well as payment schedule and all other incentives and retention policies. Some other components that should be there is the details regarding leave policy. What are the various types of leaves that would be provided? The casual leaves, earned leave, sick leave, maternity leave, etc. And what are the accrual and carry forward rules? If you don't take your earned leaves, how long can you carry forward them? All such details should also be mentioned in the leave policy. Now, termination clauses should also be mentioned properly, like what would be the notice period by both the parties if they wish to terminate this employment, and what would be the various grounds of termination. Will it be redundancy, lack of performance, misconduct, whatever it is, mention them very clearly in the contract. If you go for probation, ensure the duration of probation and what would be the evaluation process and confirmation procedure of post probation. So you're saying we will be having a 6 month and we'll see that the team lead gives a satisfactory report regarding you, then we will confirm. So ensure exactly how are you going to confirm the employment. Any confidentiality clauses you want to include, please mention them in the employment contract itself. And modern day employment contract will have non-compete and non-solicitation clauses, which is once you leave our job, you may not work in a competitor company for a period of 6 months or 1 year. Reason being, there are certain trade secrets that we have, which you have learned by working with us. We don't want you to go there and spill all the details to our competitor. That's another clause you can include. They should not violate certain provisions, which is the entire talking point of our next session. Generally, you can include such a post-employment restrictions also in the contract. What if there is a grievance regarding any of the parts? So, such dispute resolution mechanism should also be mentioned in the employment contract. Like there is an internal grievance redressal process, they can approach there. If there is, it doesn't end there, who is the person that they can go forward to? So all such details can also be given in the employment contract. Now with that, let me conclude today's session. If you remember, what we have discussed throughout this 20 odd minutes of discussion is what is a contract, what is the definition of a contract, and for a contract to be valid and enforceable legally, what are the few points that you should remember so that you can include it in the contract. We discussed it in detail, the concept of consideration, being mentally sound and of minimum age, and all those details. After that, we looked into a snapshot of a what we call as a sample employment contract, and we looked at various provisions that you should include while drafting an employment contract. And with that information, let me take a small break for today. We'll join for our next session, which is the eighth session on of the week 2, where we would be understanding the employment contracts in detail. We'll look into certain provisions which are a little trickier and how to manage it. And all those details we'll discuss in the next session. So please continue listening to this interesting course titled Legal Essentials for Human Resource Management. Wishing you a good day ahead. Thank you so much.